FCPA enforcement under the Trump administration. What whistleblowers need to know. What happens overseas doesn't always stay overseas. Instead, it could make it into the SEC's files, and whistleblowers could receive significant whistleblower awards. When it comes to corporate corruption, one law has strongly defined America's global stance, the Foreign Corrupt Practices Act, otherwise referred to as the FCPA. But under the current administration, enforcement priorities are shifting, and when those winds change, it can alter how, when, and whether some of those cases are brought. Today, I'll unpack what's really happening behind the headlines, what kinds of FCPA cases are still likely to be prosecuted, and how whistleblowers can still bring those cases through the SEC whistleblower program, even while the political winds remain adrift. Let's start with how this looks in practice. Corporate bribery rarely happens in a smoky back room with a big cigar and the bags of cash. It's subtler, more sophisticated, and usually done by professionals who think they're being super clever. Executives, regional managers, third-party consultants, whose real job is to open the doors with foreign officials with money. The motive is always the same: win or keep business in places where access to government contracts, permits, or licenses depend on influence rather than merit. Sometimes it's to secure a major infrastructure project or defense sale. Sometimes it's to push a product through customs. People looking the other way. To make sure a competitor's bid quietly disappears, which also could have antitrust implications. To hide it, though, companies falsify their ledgers. They might call a bribe a consulting fee, marketing allowance, facilitation payment. These transactions are often routed through shell companies or regional distributors, layers that give the illusion of distance between the money and the official. If you work inside a company, the red flags are often in plain sight. Look for consulting payments, agent fees, marketing reimbursements that don't make any commercial sense, especially to intermediaries in high-risk jurisdictions. A common technique is to book a bribe as a service fee, local facilitation expense, or commission adjustment with no supporting documentation or any real work or services performed. Sometimes the ledger will show nice round numbers that are transferred to third-party vendors who aren't on any approved vendor lists, or if they are, their one function is to funnel the money, or invoices describing vague tasks like market development, government relations, new territory exploration. Watch for duplicate invoices, split payments across subsidiaries, or entries coded to miscellaneous or special projects. Internal audit or compliance teams may even be told to ignore legacy accounts or strategic partners. Nothing to see here. Don't worry about these accounts. I got them. The less they tell you, the more you should think you should be concerned. These are signs the books are being massaged to hide something improper. The falsification isn't always overt. It's in the classification and concealment, shifting improper payments into categories that looked legitimate if an auditor was looking upon first blush, and within the SEC review consolidated filings. That's why FCPA enforcement and whistleblowers who can spot these schemes remain vital. What is covered under the FCPA? The FCPA was passed in 1977 to make one thing clear. You can't bribe foreign officials to win business. It has two key pillars, and this is critical. One, the anti-bribery, no payment or promises to foreign officials for a business advantage. And two, the books and records internal controls. Public companies must keep accurate records to prevent slush funds or disguised bribes. The law reaches far beyond U.S. borders. If a company trades on U.S. markets, even through ADRs, or if a transaction touches U.S. soil, it can trigger FCPA jurisdiction. The DOJ handles the criminal and civil anti-bribery cases, which may have a new whistleblower component under the new DOJ program. The SEC handles the accounting and internal control violations, which is the classical whistleblower component. Together, they brought some of the largest corporate penalties in history, from Airbus and Goldman Sachs to Ericsson, and in our case, the Raytheon Technologies for the $950 million, as well as others. The new enforcement climate. enforcement is entering a new era under the Trump administration. In early 2025, the White House issued an executive order temporarily pausing new FCPA investigations, pending review of whether aggressive enforcement was actually hurting American competitiveness. The DOJ then followed several months later with new guidance emphasizing targeted investigations, focusing on national security matters, large-scale bribery schemes, or those threatening U.S. economic integrity. Translation: routine or mid-level FCPA cases will probably get less attention if indeed they receive any attention at all. Most likely they will not under this administration. Top-tier cases, those involving defense, energy, infrastructure, or critical technology, still remain squarely in play. That means fewer cases will be open, but those that are open will be high impact, data-driven, strategic, and probably high dollar. Who's still at risk? Who do you think is still at risk to face prosecution? Here's what we believe. Defense and aerospace contractors, any bribery connected to foreign military sales or export licensing will stay high priority, especially where U.S. taxpayer funds are directly or indirectly involved and items of national security are implicated. Think about our Raytheon Technology settlement. Part FCPA, and that had part False Claims Act as well. And that showed how payments abroad can trigger dual exposure. Probably energy, mining, and infrastructure companies, especially those doing business through agents or joint ventures with state-owned entities. The Department of Justice knows those sectors are highly dense with corruption and strategically sensitive and have the potential to penetrate our country with some very suspect product. Technology and AI firms, particularly those engaging in data transfers, sovereign contracts, or licensing agreements in high-risk jurisdictions. The intersection between FCPA and AI safety compliance is also a very, very important emerging area. So even with a pause, the agencies aren't dormant. They're just prioritizing geopolitical significance and SEC linkages. There's a false sense of security out there. And here's the real danger, and it may lead to a long-term wave of cases if a new administration has different priorities. Some companies may read this pause as permission to relax compliance, even though the FCPA is still on the books. It's still good law. They may assume that because the DOJ is quieter, no one's watching, and they can get away with more. And that's a mistake. Whistleblowers are watching, investors are watching, and auditors are watching, and they step into that gap. And let's not forget about competitors, too, in blowing the whistle. This bribery is a lot like PEDs in baseball. Though a bribe is ingratiating itself with a foreign power, it was like the PEDs giving themselves unfair advantages when they played baseball or other sports. This is giving an unfair advantage to companies that are bribing, which is unfair to the companies that are not. And further, if the company falsifies its ledgers because they have to show where the money went to hide the bribes through a foreign intermediary or a different way, that accounting entry flows back to the SEC if it's public, and once it's on the books, it's an SEC violation, even if the DOJ doesn't bring the bribery case. That's why whistleblowers are now more important than ever. They're the bridge between foreign misconduct and U.S. accountability. Filing under the SEC whistleblower program. Let's talk about how a whistleblower actually acts on an FCPA matter. Under Dodd-Frank Section 21F, the SEC whistleblower program rewards individuals who voluntarily provide information leading to successful enforcement with a sanction over $1 million. If your tip leads to such a result, you're eligible from 10 to 30% of what the government collects. Tips can be filed anonymously if you use SEC whistleblower counsel like our firm or other experienced SEC whistleblower firms. Foreign nationals are eligible too. Whistleblowers are insiders, compliance officers, employees, consultants. You must carefully navigate the pitfalls of using attorney-client and confidential information. That's definitely where experienced SEC counsel comes in. Documentation is always important. You may have a fascinating story about a bribe. How do you prove it? That may be tough, and you may be the only testimony, but also look for internal emails, wire records, shell company contracts, anything showing intent to disguise or misclassify payments. Even if the DOJ took a pause on the criminal element, the SEC still can proceed civilly, and your tip may be what triggers that and makes a dormant file move forward. There's also the new DOJ Corporate Misconduct Whistleblower Pilot Program. It's designed for cases outside the SEC's jurisdiction, such as privately held companies or non-issuers involved in bribery, money laundering, or sanctions evasion, to the extent that other programs don't cover it. It offers discretionary awards, not guaranteed percentages, but still meaningful incentives for information that leads to recoveries. Think of it as an omnibus type of outlet for certain violations. So if there is an FCPA that doesn't squarely fit within the SEC's ambit, but you have great information about the bribe, it's a program to consider. Strategic perspective in closing. So where does this leave us? The FCPA hasn't gone away. It's evolving. Now, some may say it's hibernating. But when the hibernation is over, a new administration may be more interested in prosecuting cases than the present one is. And companies are going to be hard-pressed to use defenses like, hey, everybody was doing it, or the prior administration said it was okay. The prior administration, this administration never said it's okay. They indicated they wouldn't enforce or investigate a lot of cases, which is a complete difference. The current DOJ is much more selective, the SEC as well, but the program remains active. Whistleblowers play the deciding role in what gets pursued, depending upon how strong the information is. The companies that are emboldened thinking reduced oversight equals reduced risk, it's the short-term thinking, but in reality, the risk just got punted from the courtroom into the whistleblower's inbox and can explode on a later date. Because once you falsify books and it crosses into SEC's jurisdictions, what happens in Doha, Dubai, Lagos, London, anywhere around the world could still end up in the Washington enforcement files. So if you believe you witnessed bribery, kickbacks, or falsified ledgers tied to overseas dealings, consult with an experienced whistleblower attorney before you act. Your information could hold global corporations accountable and protect your rights under the whistleblower statutes.